Justice Jackson.
Yes, I have two questions, one concrete and one big picture. The concrete question comes from a statement that you make in your reply brief about MOHELA standing to earn offsetting fees. Can you spell out what those and by that I mean offsetting fees from the discharges so that we aren't even really sure, what the net loss would be? Can you spell out a little bit more about those?
Yes. So under the department's contracts with MOHELA, MOHELA receives fees for discharging accounts. And we were making the point that here, Missouri hasn't come forward with any allegations that MOHELA will actually, sum total, suffer financial injury under this plan. This is all just in service of making the broader point that any financial effects downstream on the state here are attenuated and speculative.
So we don't know really what the ultimate loss would be to MOHELA, even if we believe that MOHELA is part of the state.
That's right. The states haven't offered any evidence in that regard to substantiate their assertion of standing.
All right. And I also have a big picture question about standing. You've been arguing that standing here would be a reach if we were to, for example, find that, MOHELA somehow losses to it count for the purpose of the state based on established standing principles. And what I've been mulling and wondering is whether the same concerns about the political significance of this case that the chief pointed to could be a reason for us to hold the line in terms of thinking about our standing doctrine and whether or not we should expand it in this area. I understood that the standing bar really as applied in a case like this, would allow the political branches to hash this out without interference, from a torrent of lawsuits brought by states and entities and individuals who don't have a real personal stake in the outcome. And in some ways, it's not unlike a case we heard last week where people were very concerned about lawsuits against tech companies and how they might hobble these companies if we allowed them to go forward. And I guess I have that same worry about the operation of the federal government and its ability to govern if we look at our standing doctrine in cases like this and we find that, even the most minor state interest, a dormant fund that hasn't been funded or used by the state in 15 years, if that can be the basis for standing, I guess I'm concerned that we're going to have a problem in terms of the federal government's ability to operate. So my question is this a legitimate concern, and should we be thinking in cases like this about that type of concern as we ponder whether to expand our standing doctrines?
I think it is a legitimate concern. The court has never suggested before that it should alter ordinary Article III principles and allow plaintiffs to sue based on concerns about the significance of the action. And in fact, the court has said again and again that the fact that no one might have standing to sue about an action doesn't mean that you should alter Article III and allow a suit to proceed, because the judiciary doesn't sit as a roving commission to rule on the legality of either Congress's enactments or the executive's implementation of those enactments. But I think it would be particularly anomalous in this case to accept any of the state's attenuated theories of standing, because there isn't even a situation where there's no other identifiable plaintiff or possibility to have the courts weigh in on these issues. The problem here is that the states aren't the proper plaintiff to bring this suit.
Thank you. Have you expressed any plans to actually use the fund to pursue projects in the foreseeable future, and if so, what projects?
At this point, the projects have been put on pause.
I see. So we're talking about a fund that hasn't been contributed into because the state has waived the obligation to do so for at least a temporary period of time. And then even if the funds were to go into this particular fund, you don't have a set of plans that you are planning to pursue with them.
But all that requires is the legislature and the governor to move forward once the fund has been.
Yes, no, I understand, but we're trying to figure out the degree to which the state is injured by the money not being there. And so on the one hand, I hear Justice Sotomayor exploring with you the fact that the state has allowed the money not to be there in the recent past by saying, don't worry, you don't have to put it in there, MOHELA. So that seems to be a sort of strike against the state now, saying we're so injured because the money isn't there. And then we have, on top of that, your representation here that the state isn't even actively seeking or interested in the money insofar as it's decided that it's going to engage in some sort of project that we need the money for. So I'm just wondering about the speculative, attenuated nature of the harm that you're alleging on the basis of there not being, or of the risk that we won't have extra money put into this fund.
Your Honor, I disagree with what you said, that the state has waived the obligation under the fund. What the state has done is it's engaged in a quid pro quo discussion with MOHELA, and it has said that in exchange for $65 million in payments to the scholarship fund, it has allowed the timeline to be extended.
Yes, I apologize. I'm just saying the state has not pressed MOHELA to put money into the fund.
Because it's correct, but because it has been receiving money in another fund all
I
along.
appreciate that, but I guess I'm just still trying to understand how you can look at that fund as the basis for the injury that you're claiming with respect to this particular plan.
Your Honor, because the next due date for the fund is a year from now.
And you can't extend it?
It can be extended, but that would be in exchange for them giving another contribution to a scholarship fund, which is further showing that there are further financial contributions.
And the plan is not totally ridding them of any opportunity to make money, so they do have some other income, yes?
MOHELA?
Yes.
Whether MOHELA has other, yes, MOHELA has.
All right, so we could believe that the income that MOHELA gets from its other sources of revenue could be used to pay off in a year the amount that the state says it requires in order to put off the obligation yet again, right?
I don't think, well, here's the key point in response. What MOHELA says in the letter that the government filed as supplemental authority with the 8th Circuit is that they take all available funds beyond their expenses and reasonable reserves, and they devote them to student financial aid in Missouri. So if their operating revenues are cut by 40%, we know what they do with the money at the top, the excess money. They give it to students attending school in Missouri. So if their operating revenues go down, that's the first thing that's going to go.
And in fact, isn't that really, as you say, the most important thing if economic injury is the point?
Yes.
I had understood that the injury that was being asserted here was an economic injury, but if we look at MOHELA and we see that its financial interests are totally disentangled from the state, it stands alone, it's incorporated separately, the state is not liable for anything that happens to MOHELA, I don't know how that could possibly be a reason to say that an injury to MOHELA should count as an injury to the state.
Yes, we agree exactly with that analysis, and it's important to think about the benefits that Missouri has obtained from structuring MOHELA that way. This is not the first lawsuit that MOHELA has been involved in. Actually, MOHELA is not involved in this particular suit, but in prior suits, when MOHELA has been sued, the state's been entirely absent because state law makes clear that Missouri cannot be on the hook for MOHELA's liabilities. It creates a wall of separation financially between the two entities, and Missouri gets a lot of benefit from that.
And so if MOHELA is being injured as a result of the plan, or at least if that's the allegation, MOHELA has the ability to defend itself and its interests, correct?
Exactly. It's a separate legal person. It has the right to sue or be sued in its own name. There is nothing that stands in the way of MOHELA asserting these interests if it's experiencing financial harm, and there's no principle that would support allowing Missouri now to interfere with the separation it itself has created just because it doesn't like the policy.
Would we be breaking new ground then if on this basis we found standing?
Yes, I'm not aware of any case that would support standing on this basis.
Doesn't your theory of injury rely on the assumption that if the HEROES Act isn't there, or if there's a problem with the HEROES Act, the administration would necessarily have done the same thing under the HEA?
No, I don't think so. In fact, I think the program will look quite different once it does go through negotiated rulemaking and notice and comment.
No, I guess I'm asking you, you seem to be assuming that if you get the relief of invalidation of the action under the HEROES Act, that the administration would necessarily move forward, because you said it was a top priority of this administration, that they would necessarily do the same thing or a similar thing, meaning provide debt relief to people under the other legal avenue. And I mean, I can imagine a world, if you think of a hypothetical, in which the secretary believes that that the department only has authority under the HEROES Act. Here we are in the midst of a pandemic. The intention of the department is to provide this relief in the context of the emergency, and that if we don't have an emergency, and that if we're not in this circumstance and we don't see the HEROES Act there, then they would not move forward. So I think you kind of have to convince us that the administration would have provided this sort of debt relief under the authority you point to that you say has the procedures that were not provided.
Two responses. I think the best evidence for this is the nature of the program. The program applies to 95% of all borrowers. It's not remotely tailored to individuals who are suffering from the pandemic. And the reason is because this is a program that's just designed to help people who are in need of debt relief. And on the authority point, the parties are in agreement that they have the power to do this under the HEA. And the secretary has never come up here and denied that they won't go through the exact same process, which they should have done in the first place, once this program is declared.
So can I ask it this way? I guess I'm trying to understand why it's atextual, in your view, to focus on this idea of use of a mark as a source identifier. Because it seems to me that what you're describing as the problem is courts grappling with the degree of expressiveness of various items in terms of determining whether or not this Art Rogers exception should apply. But I wonder whether the cleaner, more sort of consistent with the statute way of looking at it is to ask, is the artist using this mark as a source identifier, as the threshold? And if they aren't, then I guess the Lanham Act doesn't apply because, as you said, the Lanham Act worries about confusion that arises from use of a mark as a source identifier. So if they're not doing that, then there's no trademark problem. But if they are doing that, if it's being used as a source identifier, then I suppose we get into all of the questions under the Lanham Act test as to whether or not there's trademark infringement. What's wrong with that?
Well, unfortunately, a lot. And with respect, that literally you're taking language in the text of parity and in the text of 1115b4, which you had a Supreme Court case on, KP permanent makeup, saying other designation of a source are actually exceptions under two statutory provisions that don't appear in infringement. So I'm fine with you making up stuff.
No, but I'm not making it up. I mean, you said here this morning, and I wrote it down, that the whole confusion issue. Do you agree that confusion is the heart of the Lanham Act?
Confusion has nothing to do with designation of source. So no, you're sorry, but in trademark law, you can have a very confusing use of a trademark.
But I'm sorry, Ms. Blatt, you said a few minutes ago that it's misleading as to origin of source or sponsorship, that's the confusion that we care about. That what the Lanham Act is trying to do is say, are consumers confused as to the origin, source, or sponsorship of this product? And I agree with you, but I'm wondering then, why isn't that the threshold question?
Just let me give you an example. The famous film pre-Rogers case, the Dallas Cowboy cheerleaders, involving 12 minutes of graphic sex involving a trademark, was not a source identifier. It was just a very confusing use of a trademark. Source, let me just explain what a source identification means. It means a consistent and persistent origin of source, even if the source is unknown. So like iPhone, even though there's not a company called iPhone that makes the phone, it's Apple, iPhone is a trademark. But you can infringe iPhone's marks or any mark without indicating it's a source. You can put it on a T-shirt, you can put it in a movie, you can sell lots of products, it's just not being used as a trademark. And the statutory definition of infringement has nothing to do with use as a source. It's any use of a mark likely to cause confusion. And I know that I'm right about this because its designation of a source is an explicit carve-out under infringement.
All right, likely to cause a confusion in what way? So fine, you put the Apple mark not on something that looks like an iPhone so that people are confused about the source of that product. You put it on a T-shirt. So likely to, how is that a trademark infringement in the sense of origin of source?
Sure, if you just put a T-shirt that says Apple sucks, that is a diluting, it's a use of the trademark. It doesn't indicate a source. It's just a statement. If you have put your favorite cartoon character in a movie, That's not a designation of source unless you, I'll put it this way, like a title is not a designation of source. Gone with the Wind is not a designation of source. It has to be, Harry Potter might be, but just standard trademark law, and you can look at any case or any McCarthy, and it'll tell you that you can violate the trademark law even though you're not engaged in trademark use.
Blockburger test, I don't understand. So you're suddenly now asking us as a result of this case to revisit Blockburger and what it says about when there are separate offenses?
No, Justice Jackson.
So you've already said that this fails the Blockburger test. That's the government's view. And I understood Justice Kagan to be saying, can we not talk about that in this case, whether it meets the Blockburger test or not, and still rule in favor of Mr. Laura? And you're saying no, but I don't understand why that is.
Sure. So we take the Blockburger test as it exists. We think under the Blockburger test, we have the better reading of the statute. We think it's a greater and a lesser included offense. That's normally one offense, but the natural consequence of that is that the penalty provisions of C apply to J.
All right. Can we disagree with that part of it without revisiting whether it's one or a different offense? You've said two different things in that. I mean, I didn't understand Blockburger to speak to the penalties in this way.
So I think one of the clues you might look to in the Blockburger analysis, and we think the clearest clue in this case, if you come out in Mr. Laura's direction, is whether it's a standalone penalty scheme or it's incorporating another provision's penalty. And I think that is how the two are related. Now, again.
And what's your answer to that question? You say it satisfies the Blockburger test, meaning that they are one in the same, like a lesser included offense, but it also incorporates the other penalty. Is that your view?
I might have lost you there, but I think what we say as our frontline position, I want to be clear about this because I think it's extremely important. Our frontline position is that these are one offense for purposes of Blockburger. That is because, J cross-references C, they're in the same section, they're part of the same, they're a greater and lesser included offense. Cases like Brown versus Ohio and Garrett would strongly suggest they're one offense. If they're one offense, we think it is necessarily true that the penalties of C are read into J, because all J is doing at that point is adding an additional element and it's increasing the penalty.
Is that what Blockburger says? If they're one offense, then the penalties of one necessarily get imported into the other. That's what I'm asking.
I don't think that's what Blockburger itself
All right, so
says.
that would be new
think
if we decided in your favor using the Blockburger standard in the way you want us to.
I don't think that's quite right in the sense that I think subsequent cases in that line look to features of the statute and sort of their level of interdependentness, the two crimes' level of interdependentness or interdependence, and one of those clues, I think, would be the way that the penalty provisions interact.
Justice Jackson?
Yeah, can I drill down on that a little bit? Because I think that's at the heart of one of my concerns about the burdens and some of the questions that we've heard. So you put on Mr. Trendy at the district court, and my understanding was that Mr. Trendy did not really, as an expert, undercut the methodologies of Ragusa and the other experts. Is that correct? I mean, he didn't put forward an alternative or do a kind of methodological analysis of Ragusa, did he?
He did point out some of the flaws in these expert reports, including this use of total numbers instead of percentages. He also talked about the contiguity issue in the county envelope analysis I was just discussing with Justice Barrett.
But
he did.
Oh, sorry. So he did.
He did point out some of these methodological flaws, and we pointed them out also to the district court.
And what if the district court disagreed? I mean, the district court ultimately relies on Ragusa's expertise, and you say that you challenged, although you did not really bring an expert report that met Ragusa at the same level, but you raised the objections, and the district court disagreed, apparently, right?
That's correct.
Okay. So I guess what I'm concerned about is that I kind of hear you wanting us to do a de novo review as opposed to a clear error review. Because to the extent that you're now asking us to look at the flaws in Ragusa's testimony and I guess disagree with the district court's crediting that report, that sounds to me like de novo. I understood from Cooper that the clear error standard, and I had it here a second ago, is a highly deferential standard that the court may not reverse just because it would have decided the matter differently. A finding that is plausible in light of the full record, even if another is equally or more so, must govern. So to what extent do we have to credit the district court's disagreement with your objections to Ragusa's report?
It's a great question. Let me give a couple of responses. First of all, as you've just read from Cooper, the court has to consider whether it's plausible in light of the entire record and all of the evidence. And here the district court just ignored other evidence that was put forward. What we are asking the court to do is exactly what it did in Cromartie 2. In Cromartie 2, there was a plaintiff's expert who did an analysis of VTDs moved in or moved out or potentially available to the district. The state also put forward an expert to give the contradictory interpretation of that evidence, but the district court excluded that expert.
Yes, but wasn't there wasn't Cromartie 2 a majority-minority district scenario?
Sure, which again is all the more reason why the racial target theory in this case just makes no sense, because there's no clear motivation.
No, I understand. You're sort of shifting. I guess I'm just so keep going. Cromartie 2,
so
you're asking us to do
Cromartie
the same thing.
We had exactly the same situation with experts. The district court had excluded the defense expert, so that expert wasn't really considered by this court on review. But this court went through as part of clear error to ensure that the district court had not relied on clearly erroneous expert testimony and a bad methodology. That's what most of Cromartie 2
But how does clear error work in that? So, I understood the standard now, post-Cooper, to be, is it plausible that the district court could have relied on Ragusa's testimony and could have found it to be reliable, and in the absence of a defense expert that's actually poking methodological holes in it, I think you have a hard time. If our burden is just to say, was it plausible that the district court got it right in terms of the crediting of the Ragusa's report?
I don't think that's exactly what the clear error standard requires.
All right, so tell me what it requires.
Is the district court's finding of predominance as a finding plausible in light of the whole record?
And that includes both the expertise and also the district court's credibility findings, which is another sort of aspect of this that I really wanted to pin down. You say the district court ignored other evidence, but it did have a trial, and it had the actual person who drew the maps come in, and there's testimony in the record where the court itself is questioning directly, not relying on the attorneys, but actually putting questions to that map drawer. And I'm just wondering how we are to assess the court's determination that it disagreed with or didn't believe the expert when he said, I was looking at partisanship and not race.
It was not a credibility determination because the court never based that on his demeanor on the witness stand or a trial. The court credited other evidence, but there was also other evidence the court didn't even discuss.
So are you saying the court could not have disagreed? I mean, they asked him the question, moving that line up into the African-American areas of North Charleston, you would say was for a partisan lean, correct? And the witness says yes, and they ultimately find that that's not so. So why isn't that a finding? I disagree. I don't believe you.
A credibility determination, as we pointed out in our reply brief, requires a determination about the demeanor of the witness on the stand. Otherwise, district courts could always wrap their fact findings in credibility determinations in an attempt to avoid review. They didn't even do that here. There isn't that kind of classic credibility determination. But even setting that aside, there was all kinds of direct testimony from Senator Campson, who was the sponsor of the bill, from Senator Massey, who was the Senate Majority Leader, from Representative Jordan, who also testified about text messages in the record.
So what would a plaintiff have needed? And this is my final question. I'm short on time. What would a plaintiff have needed, in your view? Direct evidence, a statement that says we are using race and not partisanship in this particular area.
That, or an alternative map that disentangled the two, or, if you think the alternative map's not required, a full evidentiary picture that showed that traditional principles actually were subordinated to race. And here there's been no showing, for the reasons I just discussed with Justice Kavanaugh.
Thank
you.
A
line in Charleston County complies with traditional principles.
Thank you.
Thank you, counsel.
Thank you.
Justice Jackson?
So I guess I'm still not clear why the onus isn't on the government official to be clear about the capacity in which they're operating. I mean, I take your point that you can have an individual who's a public official and they can operate in both worlds, official and also personal. But to the extent that we're having a problem, or at least I'm having a problem, it's because we can't identify whether this particular action is occurring in one world rather than the other. And we've said in lines of cases like the Pickering line of cases, we've recognized that even though public employees have a First Amendment right to speak, they can be limited in that ability to speak. So it doesn't seem responsive to me, at least, for you to say, well, they have a First Amendment right, so they bear no responsibility in making clear as to when they are operating personally versus officially. So can you just say more about that?
Sure, I'll try. I'll say three things. So the first is, again, the conduct that they're objecting to is the blocking. Right. This is not a case where they're complaining because they were confused, that they thought it was official, and if they had known it was official, something else would have happened. Everything in this case would have been exactly the same if that page was plastered with disclaimers.
Yeah, but it's not, no, I guess what I'm trying to understand is when we isolate the blocking, and you're right, that is the claim, we have to think about, as Justice Kagan pointed out, the implications of that on the First Amendment rights of the people who want to see the page. So what's happening is they're being blocked from either commenting or seeing the information that's being posted on this particular page. And when the official says, but that particular page is my private page and I'm operating in a private capacity, then I suppose we have one set of answers. But if we believe that that page is actually operating as the official government page and the person is being blocked, we might have a different set of answers. So the question is, with respect to the blocking, is it happening in a personal or an official capacity, and why wouldn't it be the public official's responsibility to say, if you're on this page and you're either seeing or not seeing things, understand this is a personal repository of information?
Right. So, again, I guess what I would say, Your Honor, is if you concede that my clients could have done this in their personal capacity with disclaimers, the question is where in the Constitution are they obligated to put up the disclaimer if they want to maintain those rights?
If they want us to believe that they're doing it in their personal, I mean, well, how else are we supposed to know? Well, I mean, that's just one set of questions.
To be fair, they've got the burden of proof. They're the plaintiffs in this case. They're the ones who are arguing it's state action. So the burden should be on them to show the opposite, not on my clients to disprove it. The second point I would...
So you're saying that a public official can just make a decision sub silentio about which world they're operating in, not let anybody know, and it would be the burden on whoever is saying that you are violating my constitutional rights to determine that you were actually operating in the official capacity.
In a case like this where there's no objective indicia that they were doing it in their governmental role, there's no staffing, there's no resources, there's no control.
What about the page, the way it looks, the way, this is the other argument,
Everything
right?
about this page's appearance is equally consistent with a campaign page. That's exactly what happened in the Eighth Circuit. A page that looked no different than our page, the judges just split, saying,
Okay.
well...
Can I just ask one more question? I'm sorry. Justice Sotomayor came up with a private hotline example to seek emergency help that I thought was really interesting. I hadn't thought of it before. And I understood you to say that the response, the government rushes to your house as a result of getting the communication, would be official action. But I guess I'm not clear as to the blocking that would occur by the official from people that they didn't like with respect to a page that was designated as, this is the opportunity to call for government help. I'm creating this Facebook page so that people can have a straight-through hotline to government resources. The person, I guess, is saying this is a private page so I can block, Latinos. I don't want any Latinos on this page, says the person. Is that a problem? Or, I mean, is that state action or not state action?
I would think if that's all there is, I would say it's not, because a private citizen could set up that exact same page. This is a page to get you access to government.
But if they did, wouldn't that implicate all of the lines of cases where we talk about or we think about whether or not a private citizen is actually acting in a way that's fairly attributable to the state? I mean, we don't just stop at saying, oh, a private
I don't
citizen.
think any of those tests would be met. The
one about joint action between the private party and the state, the Brentwood Academy line, where you're looking at, is this facilitating a state service, you think would not apply?
I don't think, again, if a purely private citizen, just think, a wealthy person in the city said, I want to make it more easy for people to call and get access to government things, and sets up a page like that. That's not joint action. He's acting wholly independent of the government.
All right, thank you.
Justice Jackson?
Can I just quickly return to Justice Alito's hypothetical, which I think is a little bit helpful in trying to pinpoint a problem that I've been having. It seems from the race hypothetical that if there was only one basis for giving someone a boost, and that basis was race, then I see disadvantage absolutely to anyone else who's not an underrepresented minority who can get that boost. But I understood that we have here a program in which there are at least 40 different bases for being able to get a boost. And not everybody who is an underrepresented minority gets a boost. So it's really hard to figure out if anyone is being disadvantaged in a system like that. And that's where I was worried about standing, because I'm trying to understand how the system is operating to actually advantage minorities in a way that is harmful to anyone else in this system.
Yeah, and I think that attributes to the careful cue that UNC has taken to this court's decisions in Fisher 2, making sure, universities find themselves in this Goldilocks problem about, considering it too much or too little. The university.
But there are other considerations is the point. Everyone can get a boost for all sorts of reasons. Minorities don't automatically get a boost under this system. So it's hard to know whether anyone's being disadvantaged from the mere fact that a minority could get a boost in this environment, right?
That's right. And the evidence also bears it out at Petition Appendix 78, where the evidence showed that hundreds of white students with lower combined GPAs and SAT scores were admitted ahead of higher performing Black students, Latinx students who went to UNC. And I think that bears the hallmark of the type of individualized consideration that this court wanted.
I'm certainly happy to embrace the limited public forum analogy that I think has been the subject of some of these questions, because at the end of the day, I think it ends up in the same exact place as intermediate scrutiny, and if I could try to explain why. So two things are important about the limited public forum reasonableness test. The first is it's not rational basis. There's something more going on there. If you look at the opinions in Christian Legal Society on both sides, I don't think anyone on the court thought that they were engaging in rational basis review. So there's some assessment of whether the fit is appropriate, and some lower courts have likened that to intermediate scrutiny. I know your question earlier suggested that it's different, but I actually think that the reasonableness review and intermediate scrutiny are more alike than they're different, and neither one is rational basis. But the second point, and I think this is critically important in this context, is there's a nexus requirement that exists in the limited public forum set of cases. The question for the court isn't whether the restriction at issue is reasonable in light of any purpose, but in the light of the purpose of the forum. And even if you want to accept the idea that the forum here is not the government registrar, but the government registration system, I think the problem for the government is this clause really has nothing to do with that. And
why are you saying that? Why are you saying that? I mean, Mr. Stewart just made a very robust argument about why this is advancing the purposes of the trademark regime.
Well, the purposes of the registration system, Justice Jackson, you can see this in McCarthy, Section 19.2. The goal of the registrar is to make registration and use as coincidental as possible. Basically—
No, but it's not just it's the trademark regime of which registration is a part. And trademark is not about expression. Trademark is not about the First Amendment and people's ability to speak. Trademark is about source identifying and preventing consumer confusion. And it seems to me that Mr. Stewart was making the point that by having a restriction on people trademarking living people's names, the government is actually furthering the interests of the trademark system because it prevents confusion regarding whether or not this is endorsed by the living person, this is the living person's thing. You can imagine a lot of circumstances in which having a trademarked name could cause confusion in the marketplace. So why is that not a rational basis for saying we won't allow people to trademark names?
So you're absolutely right, Justice Jackson, that the purpose of trademark law in general and the purpose of the registration system, as the opinion of the court in the Jack Daniels case from earlier this year makes clear, is to ensure that marks function as trademarks, that is, that they function as source identifiers, and they're not likely to confuse or mislead consumers as to the source. You're totally right about that. That's the purpose of trademark registration and the trademark system more broadly. But what's so unique about this clause is there are other provisions of the Lanham Act in Section 2 that deal with the hypothetical that you just gave.
You're just saying it's superfluous. That doesn't tell me it doesn't have a nexus to the purpose.
Well, I think in analyzing whether the provision that is before the court is constitutional, I think it's appropriate for the court to take account of the practical effect that clause has. Because if it's invalidated, then the government is still going to have ample tools at its disposal to ensure that there's marks are not registered if they may falsely suggest a connection between a product and living persons, if they're deceptive, if they're likely to confuse or mislead as to source, if they don't function as trademarks.